reputation, which is very, very important. Um, so we are going to start with the Indian Contract Act. So, Shivam, what is happening? Why are you sending so many posts? Why are you posting?
No, ma'am. Actually, I started the recording and someone else stopped it.
Okay,
So the video is being saved.
okay. So let's start with Indian Contract Act. Business comprises buying and selling of goods and services, and the sale of purchase of anything constitutes an important contract. And it regulates the commercial activity. Fine, I mean, that's it. Now, few things. First of all, contract starts with agreement. Okay, agreement means what? I have an agreement with you. That means what? I mean, you and me, we are both agreeing on the same thing and in the same with the same meaning, right? That is agreement. But any kind of an agreement enforceable by law is a contract. So what is contract is not agreement. If I am making some agreement with you, I am in agreement with you, that doesn't mean that we two are making a contract which is enforceable by law, right? So when an agreement is enforceable by law, that is contract. So there are two things. One is there must be an agreement, that is both of you are agreeing on the same thing, and there is a legal obligation, that is you are binded by law. So every promise and every set of promises forming the consideration for each other is an agreement. So here all the terms are important. What is a promise? A proposal, when accepted, becomes a promise. Okay, proposal means you are offering, you are making a proposal to someone, and then when he is accepting it, it becomes a promise, right? And here the one term also we have found, that is the consideration. Consideration means in exchange of something. When you are giving something, when you are agreeing with something, you want something in return. So this is the consideration. For if there's an agreement between A and B, what A is giving and what A is getting in return in exchange, so that is the consideration from A's point of view from B, and similarly with from B's point of view. Okay. So starting point of a contract is a promise or an agreement. The formation of an agreement requires that the meeting of minds between parties. Parties must agree upon the same thing in the same sense. So same thing, same sense. I mean, what you are communicating, your friend should understand that what language you are trying to convey and whether he is sensing the same thing. So that is important, the same sense. For example, if A offers to sell the car to K, K accepts this offer. This offer after acceptance becomes promise and it is treated as an agreement between A and K. So A is making an offer or proposing, and K is accepting. When both the side, you remember I said that there's an executed and executory. Okay, so you have made the offer, he has accepted, so then it is becoming the agreement. So then agreement consists of an offer by one party and its acceptance by the other. So that is the agreement. Now enforceability, when it is enforceable by law, it creates a legal obligation. This obligation is a legal tie which imposes upon the determinate person or persons the necessity of doing something or abstaining from doing a definite act. So there may be an agreement that you do something for me or you don't do this. That may also, abstaining from doing something can be and also be an agreement or a contract. Okay. So an agreement is a wider term. So even if it is not enforceable by law, there is an agreement. But when it is legal, then it becomes a contract. So contract is a narrower term in that sense. Agreement plus legal obligation makes a contract. So what is the process? Offer, then acceptance, then promise or agreement, and it becomes the contract. Um, so we can say all contracts are agreement, but all
Excuse me,
agreements.
ma'am.
Yes.
So if A and K were in a car deal, right? So
Mm-hmm.
he
Mm-hmm.
offered maybe let's say 10 lakh it was written. So
Mm-hmm.
and if D comes in and they have both like mutually verbally agreed on, like he came
Mm-hmm.
to me and A came to K and then said that I want to buy this car for 10 lakh, and he said okay,
Mm-hmm.
I'll sell you.
Mm-hmm.
And then the next day I went to K and told him that I am willing to give him 12 lakhs.
Mm-hmm.
So can he accept my offer as well, or and deny the other person's offer because he has verbally accepted
Yes,
but no written,
yes,
but
so he
because he
can
has
deny,
promised but
but
nothing
it
has
is not
been.
enforceable by law. So you cannot
Okay.
sue, you cannot take him to the court, isn't it? So that is the contract. You have made agreement, but you have not made a contract.
Okay, so if I have made agreement, I can break that, but
Yeah,
contracts cannot be
I mean
broken.
you cannot break that. It actually, I mean, will dilute the images, right? It is
Yes.
going to, but I mean, by law it is not enforceable. So you cannot
Okay.
sue him. Okay, so that is the point.
Yes.
Okay, so
Ma'am,
having
what do
said,
you mean by dilute the images?
I mean, your credibility will be no
Reputation.
more, right? Reputation. Yeah, reputation, your credibility. I mean, you have given some words, but you are not keeping your own words. So, I mean, it is not a good image you are carrying, right? So that is what I am saying. So maybe, I mean, you can break your own promise. That is always you can do, but it depends on between you two. So it is not that you can take him to the court. That yes, only that you can, if it is, I mean, legally it is approved, then only it is a contract, and then only you can make a formal suit. Okay. Okay. So, I mean, that is what I mean. These examples are just see X invites his friend Y to a dinner and Y accepts the invitation. If Y fails to turn up, so can he take his friend to the court? So, it is not that we do, right? So, these are the examples of agreement. Whenever there's a promise and whenever there is an acceptance, so there is an agreement, but that not necessarily it is a contract. Okay. So this kind of, I mean, this is a very simple thing, but this kind of small cases may I give to just understand that what you have meant by these concepts. Okay. So here there is a case by the husband and wife. Okay, where husband has promised wife to give amount of money every month, but later on he refused. So since it was not made under a contract, okay, so that's why it is unenforceable. Why I am it is not a business law, right? So why I have used this example, because in the next example you see that in commercial or business agreements an intention to create legal relations is presumed. Thus, an agreement to buy and sell goods intends to create legal relationship. Hence, is a contract, provided other requisites of a valid contract are present. But if the parties have expressly declared their resolve is not to create a legal obligation, even a business agreement does not amount to a contract. So, what is the difference between the business agreement and other agreement? So, in case of business agreements, it is presumed that the intention is to create a legal obligation. You are buying a good, somebody is selling a good. Okay, so it is presumed that there is a legal obligation. But in case of other kind of agreements, there is no such presumption. So in case of, just say for example, the previous case where what I showed, here you need to explicitly mention that it needs to be enforced by law. Then only you are legally bound. But in case of business agreement, you need to explicitly mention that we are not legally bound. I mean, this agreement is happening without any legal intention. So then only it will be presumed that it is just an agreement. So this is the difference. Here it is presumed as not enforceable by law. In business agreement, it is, I mean, it is enforceable by law. That is presumed. That is a presumption. So that's why if you just take this example, there was an agreement. There's a I mean a case between these are not very old cases, but these are I mean good examples, and these are always discussed in terms of while these particular concepts are taught. Okay, so that's why I mean these are the very popular examples. You can go and search for these examples in the Google also. You can get the I mean explanations there. Just hold on. So there was an agreement between two companies by means of which the former was appointed as the agent of the latter. One clause in the agreement was this agreement is not entered into blah blah blah, and as a formal or legal agreement, and shall not be subject to legal jurisdiction in the law courts. So since there was no binding contract, as there was no intention to create legal relationship, so it was held. So that means it cannot be maintained. I mean, the suits cannot be maintained. Why? Because though it is an agreement between two companies, um, but it is explicitly mentioned that it is not for any legal purpose. So that's why one cannot sue other. Okay, so that is the difference. Um, okay, so this is the difference between agreement and contract. I mean, you can read it on your own. The same thing has been discussed again. Now, which is the most important in Contract Act? You need to remember these um, 7, 8 elements. When we can say a contract is valid, each and everything has to be present. Then only you can say the contract is valid. The first is there must be a proper offer and a proper acceptance. Now, offer acceptance, what are the, detail I'm coming into? Lawful object and consideration. So the purpose, what you are doing, what contract you are making, the purpose should be lawful. And you cannot bribe someone. That is not lawful. That is not, that does not come under law. So even if you are making an agreement or whatever, it does not come under the, I mean, in eyes of law, it is not accepted, right? So, and consideration. Consideration is also an important thing. That means what you are getting in return. So you cannot, offer someone to kill somebody else, right? So this is the consideration is not lawful. Now, free consent. The consent must be if you can force other party. You cannot, get a promise and get an acceptance at a gunpoint, right? So the offer must be, willingly somebody. I mean, they should be free. The consent should be free. The capacity to contract, whether the particular party is capable. I mean that eligibility. There are certain criteria. Which are the parties? What we mean by the capacity? So you cannot make a contract with a minor, right? And then you cannot say that, yes, I have made a contract. So there are specific criteria. Agreement not expressly declared void or illegal, which all of us know that it is illegal at the very beginning. So that agreement is not considered as contract. Certainty of meaning. What are you meaning? So, for example, you are telling it that I'm going to sell this car, sell a car. So, what car you are meaning? Your customer is, thinking that some other car he has in his mind, and you are talking about some other car. So, certainty of meaning. Then possibility of performance, whether it is at all, possible. If something absurd you want, even if there is an agreement, it is void. And legal formalities, that the technicalities, if it is written, the signatures, the stamps, all these registrations, all these are the technicalities. Those things should be there. So these are the elements of the valid contract. And how the contracts are classified. So as per the enforceability, there are valid, voidable, void, unenforceable, and illegal. I'm coming to this. Method of formation, express, implied, or quasi-contract. And extent of performance, either it is executed or it is executory. Okay. Now, what is void contract? A contract which ceases to be enforceable by law becomes void when it ceases to be enforceable. That means it is from the very beginning only, it is void, it is not valid. A void contract is valid and binding upon the parties when entered into, but subsequent to its formation, it becomes unenforceable due to certain reasons. And why it becomes void? Due to any supervening impossibility, change of law, or others. So this is void from both the parties. It is not anymore enforceable. Even at the time of the making the contract, it is valid. But then also, due to some other reasons, it may become void. But when it is called a voidable contract is an agreement which is enforceable by law at the option of one or more of the parties thereto, but not at the option of the other. So what does it mean? And since it is at the option of one or more party, but not at the option of the other, so It is repudiatable. That means it can be cancelled at the option of the aggrieved party. It remains a valid contract until it is set aside or rescinded by the party. So means you and your friend or A or B is making a contract. So it is repudiatable or cancelled. It can be at the option of the party B, but till the time he is not raising the concern, he is making the acceptance, then it is valid. But it is voidable but valid. But when he is going to raise, then only it becomes voidable. So coercion, undue influence, fraud, misrepresentation, all the factors are there for which are responsible for entering into a contract. So by forcing someone, you have made a contract. But later on, if that person says that it has been done by force, so then it becomes void. Okay. So void contract cannot be enforced by either party, and voidable contract, it can be enforced or set aside at the option of the aggrieved party. Relationship, a void contract under no circumstance result in a voidable contract. So when it is void means void. A voidable contract can be is repudiatable by the aggrieved party when the aggrieved party will raise his concern, then only it results into a void contract. Compensation, in case of void contract, question of compensation or damage does not arise on the non-performance of such contract. So it is not anybody's fault, right? Because of some third reason, it has become void. So there is no question of compensation. But in case of voidable contract, the party rescinding the contract can claim the damages. And effect of lapse of time. Lapse of reasonable time does not render a void contract enforceable. It remains always void and unenforceable. But if a voidable contract is not rescinded by the aggrieved party, it would become enforceable at the option of the other party. So if you have not raising that you are, you are under, you have been, uh, the fraud has happened with you or there is a misrepresentation by the party. If you do not resign, then it remains valid, right? It will not be a void contract anymore. So this is an example that just I told, that if it is done by force, then it is voidable contract. Unenforceable contract, what do we mean by that? A contract which may be valid otherwise but cannot be enforced by one or both the parties because of the technical flaw, such as the need for the registration, attestation, and all this. So it becomes an unenforceable contract. Illegal agreement. Illegal agreement is one in which the law specifically forbids, and illegal agreement is void ab initio. That means from initiation of the contract only, agreement only, it is void. In the eyes of law, not only illegal agreements are unenforceable, but any other agreement collateral to or arising from such agreement is also unenforceable. Just read the example. So here you see that A agrees to pay an amount for killing another. So automatically it is illegal, right? So it is an illegal agreement. So A manages the amount by taking a loan from X to pay B. So A does not have the amount. He has taken a loan. Now X is aware of the purpose of the loan. It is with the awareness of the purpose of the loan, X has given the loan. In this case, the main agreement between A and B is illegal and void ab initio because its object is unlawful. But even B kills C, he or she cannot recover the agreed amount from A through a legal action. Obviously, besides the main agreement between A and B, the collateral between A and X is also void in the eyes of law. So now if A does not repay the loan to X, since X was aware of the, so it is an extreme example, right? So when X was aware the purpose is not lawful, so he also cannot recover the, the payment. Okay. So the
But if
collateral
he
agreement
was
also
unaware,
becomes
then
void. Yes.
if X was unaware about the purpose,
Ha,
then
so that means that X was unaware, so there is no problem.
so he can
Then he
recover
can,
the amount.
yeah, he can recover. Okay. Okay, now the quasi-contract, the act of a person permitted by law by which he obligates himself towards another without any agreement between them. What is the example? See, in the example is a case of a delivery boy who by mistake delivers, it happens many a times, right, to the wrong address. Now the owner of the house consumes the supply. So even he knows that, I mean, he has not, it is not meant for me, he consumes. The question arises if the owner will be held liable for the payment. Yes, the man will be held liable for the payment as a law aims to create an obligation upon a non-contracting party to avoid injustice. So he obligates himself towards another without any agreement between them. So who the person who consumes, he is not entering into an agreement, but it is that he obligates himself by consuming that particular thing which is not meant for him. So automatically he is there's an bound by, he is bound by law. Okay. Now, executed, a contract is said to be executed where both the parties have done. So it is, these classifications are, one is according to the validity, the void, voidable, unenforceable, valid, illegal, and all this. One is the execution, executed or executory. A contract is said to be executed where both the parties have done all that the contract is required, in the contract is required. A cash sale is an example of executed contract. And executory, these things you know very well. The considerations are yet to be carried out. Contract in which one or both the parties have still to carry out their respective obligations, those are executory contracts. So this you know, right? Acha. So just I mean, these are the small examples. Just let me know from you whether the offers are valid or not. Number one, A has two PCs. He offers to sell one to B while B is under impression that that he is buying P4. How would you deal with the communication gap in the context of the Indian Contract Act? So please raise your hand and answer it. I mean, it is just to check your understanding. Yes, Reyash?
Hello, ma'am.
Yes, I can hear you. Yeah.
Ma'am, it is not actually a valid contract because
Mm-hmm.
all the specific details should be mentioned in the
Hmm. So
yeah.
what element is missing here?
The
What
mo
element is missing here? I have mentioned few elements, right?
Yes, ma'am.
So what element do you think? Should I show you the elements?
Yes, ma'am.
Okay. Okay,
Ma'am,
let me show you the elements of the contract. Yeah, tell me,
ma'am,
Shreyash.
um, certainty of meaning.
Certainty of meaning. Yes, true. Okay. So this way you need to answer. Did you understand? I mean, if I give such a small examples, you just need to I mean, make your logic putting what elements are missing of the contract. Okay.
Repeat
Okay.
the elements again. Excuse me, ma'am.
Yes.
Can you please repeat the elements again?
Certainty of meaning. What's Shreyash
Not
mentioned.
type elements, like what are the different types of elements?
Oh, acha. That I showed, na? Here. These are the elements.
Okay, ma'am.
Got it. Okay. The next one. There's one more example. A agreed to pay B if B shifted his real estate business from the area where the former was doing the same business. B promised but later refused to do so. Discuss the validity of the agreement. Yes, Divyam?
Ma'am, as it was just a promise, so it was not enforceable by law, but in that one slide you told that the business propositions are generally enforceable by laws. And
Mm-hmm.
so it should be enforceable then, because in business
No,
prospects, in personal prospects, there were, you said that as
fine,
that
fine. Divyam,
wife
I
didn't get
understand.
the
I
money.
understand. But I mean, what about the elements of contract? Are all the elements of contract it is there?
No, ma'am.
Which element is missing?
Legal formalities.
Yes, ma'am.
Legal formalities. What? Anything else?
agreement not expressly declared void or illegal.
No, no, that is not an element, right? What are the elements? Certainty of meaning, possibility of performance,
Lawful
your
object and
lawful
consideration.
object and
Here
consideration.
was
Yes, the
no
purpose.
lawful
Yes,
object, right?
true, true, true. So the object is not lawful, right?
Yes, ma'am.
He's actually kind of bribing him that you
Yes, yes,
shift your business from here. So lawful object and consideration is missing here, right?
yes, ma'am.
So that is the element is missing. Okay, you try to, I mean, just you need to remember what are the elements and you try to explain your, I mean, put your logic based on that this element particular is missing. Okay, this way. The next is the A offers to sell B 100 liters of oil. Does it constitute a valid offer? Okay, so I'm not talking about contract, valid, whether it is valid offer or not. So I let me also specify that A are the seller of different types of oil. So A is offering 200 liters of oil. Okay. So is it a valid or not? Let me ask someone else. Yes, Ritik. Ritik, you have not answered before.
Yes, ma'am.
Ah.
Regarding the first point only, if there is no proper acceptance of the offer in regard of the, and there is also not proper offering where A has specified the quantity or the quality of the oil.
Yes, yes, yes. So again, there is an uncertainty, right? The meaning is not, there's a not, when it becomes a, I mean, when we, even in agreement, we agree on the same thing in the same sense, right? So what do we mean by, what does it mean by the oil? We do not know. Only by saying oil, it is not going to be a valid offer, right? So if he is a, I mean, vendor, if he's a seller of so many types of kinds of oil and he is saying that this is 100 liters of oil, so what do we mean by that? He needs to specify, right? Okay, so this way you please I mean try to give your answer. So these are the very beginning examples. I mean, later on we will have more interesting examples when we will move forward. Now, the offer and acceptance. Offer is a starting point in the making of an agreement, and it is also called proposal. Um, okay, so our offer is from a person when he signifies to another his willingness, as I say, to do or to abstain from doing. Both can be an offer. Okay, to do or to abstain from doing anything with a view to obtaining the assent of that offer to such act or abstinence. And you are also accepting that, yes, you do or yes, you do not do. So this act or abstinence, both. So an offer involves the following. Acha, can you see the slide? Is it, can you properly see
Yes.
the slides? Okay.
Yes, ma'am.
An offer involves the following essential elements. What are those? It must be made by one person to another person, obvious. It must be an expression of readiness or willingness to do or to abstain from doing something. And it must be made with a view to obtain the consent of that other person to the proposed act. Why it has been, I mean, specifically it has been mentioned, these are the elements. We will do some examples later. The person making the offer is called offerer, and who is accepting is the proposee or offeree. Now you see the different types of offer. You will find it, why it is interesting. So general offer, when the offer is made to the world at large. The case here is mentioned. Let me see. Yes, it is there. Specific offer, when the offer is made to a definite person. An implied offer, an offer may be implied from the conduct of the parties or the circumstances of the case. So the case here mentioned is the Carlyle versus Carbolic Smoke Ball Company. What was it? So Carbolic Smoke Ball Company issued it is a, I mean, real life case. It has issued an advertisement. It means the company offered to pay £100 to any person who contracts influenza after having used their smoke balls 3 times daily for 2 weeks according to the printed directions. Now, Mrs. Carlyle, on the faith of the advertisement, bought and used the balls according to the directions and suffered from influenza. She sued the company for the promise revert and the company was held liable. Okay, so what kind of offer it is? Tell me.
General offer.
General offer. Okay, so it is a kind of general offer. It is meant for anybody. You are not making any specific offer to a specific person. So anybody who is I mean accepting your offer. So he can, take you to the court. Okay. So legal rules to the offer: certain and unambiguous terms, intention to create legal relationship, different from an invitation to offer. We have examples of invitation to offer that we will discuss. Then proper communication must be made. So in case of general offer, in that particular case, the communication was properly it was communicated to to the mass. No term of non-compliance of which amount to acceptance. So there, the offer cannot be that if you do not comply, then I will think that you are going to accept it. It is not that. It is not so. Communication of special terms. If there are special term involved in that agreement, you need to be communicated. Different from a mere declaration of intention. It has to be a proper offer. So let us take the examples one by one. Intention to create legal relationship. An offer must be such that when it is accepted, it will create a legal relation. In the terms, the offers are vague or indefinite, its acceptance cannot create any contractual relationship. Those examples we have already done. Now, how it is different from an invitation and offer? What is invitation to an offer? In an invitation to offer, the person making an invitation invites others to make an offer to him. It is prelude to an offer inviting negotiations or preliminary discussions. Examples are display of goods in showrooms. Examples are auction sales. So when there is a display of goods in showroom, that doesn't mean that you are making the offer. So now when the person who has decided to buy that good, then he is actually now buying that good. That is the offer he is making. And when you are taking the payment and giving him the goods, then you are accepting. So display is an invitation that you make the offer. Similar with auction sale. So here's a case mentioned: an auctioneer advertised in a newspaper that a sale of office furniture would be held. Now a broker came from a distant place to attend the auction, but all the furniture was withdrawn. The broker thereupon sued the auctioneer for his loss of time and expenses. So he came from a distance. He has spent some time and expenses. So it was a wastage. So he sued, but it was held. Auctions are invitation to treat and not offer. So this is an auction. Now you come, you select what you are going to buy, and then I'm going to sell it finally. So that buying and selling when will happen, that is the um, actual offer and acceptance. When I'm inviting you that you come, that is not an offer, it is an invitation to offer. Okay. So that's why it is not a legal contract. Offer must be communicated. An offer must be communicated to the person to whom it is made. An offer is complete only when it is communicated to the offeree. Acceptance is not possible unless offer is brought to the knowledge of the offeree. That is, one can accept the offer only when he knows about it. Acceptance in ignorance of offer confers no right. That is, an offer accepted without its knowledge does not confer any legal rights on the acceptor. So there is a case mentioned here, Lalman Shukla and Gauridat. What happened to it? That is, Gauridat as his son or daughter, someone, or his nephew or niece, someone. He was lost. So Gauridat declared that whoever will find, will go and search for him, and they find him, he will make an offer. So that Lalman Shukla, that particular person, was not aware of that notification. And he then later on he found, and he came to Gauridat and he claimed the money. But ultimately, Gauridat is not bound to pay him the money, because Lalman Shukla at the time when he was finding the boy, he was unaware of the offer made. Okay. So now he cannot say that yes, you just give me my claim amount. Okay, because he was not aware of the offer. So since he was not aware of the offer, he cannot be an acceptor of that particular offer. Okay. No term of non-compliance of which amounts to acceptance. The offer must not contain a term, the non-compliance of which amount to acceptance. Example is given: A offers by
Ma'am,
post. Yes.
ma'am, you talked about being aware, right? How will somebody prove that you are aware of the offer or not?
Yes,
that
ma'am.
that comes, I mean, that is a separate question, right? That is a separate question. Now, who will be the witness, who will be the, how you will, what documents you will show that yes I know, those are the other things. I mean, the point is, if you can prove yourself that, I mean, I was aware, that is a separate question. But it cannot be proved, then if you are not aware it is proved, then it cannot be a valid offer. Okay, I mean valid acceptance. A
Okay.
offers by post to sell his horse to B for rupees 2000. He writes, if you do not reply, I shall assume you have accepted the offer. So there will be no contract even if B does not reply. So any day somebody can tell you, so I'm sending you this particular goods, and if you do not accept, then I will, if you do not reply, I will assume that you have bought that goods, right? So there should not be any kind of contract like this. So mere non-compliance of which cannot amount to acceptance. That is the point here. While making the offerer cannot say that if the offer is not accepted before a certain date, it will be presumed to have been accepted. No, you cannot say, like, you cannot make a contract like this. Communication of special terms or standard terms of contract, special terms of the offer must also be communicated. If it is not communicated, the offeree will not bound by those terms. Okay. Okay. So this is all about the offer part of the agreement or contract. Then comes the acceptance.
Excuse me, ma'am.
Yes.
But we
Acha,
can do
yeah.
that if before this certain date you do not reply, that means you have denied the offer.
No, no, no. I mean, if somebody says some, book publisher is sending you a book and saying that no, you need to, I mean, if you are not answering to my mail, I will assume that you have bought this book. Is it possible? You say?
No,
Tell
no,
me.
but if I am just doing the opposite, that if you are not replying, then I will presume that you are denying to this offer, and I will sell this book to someone else. So
That's not, I mean,
later on they can't sue us, or they can take us to the legal
no, you
management that
cannot. It
they
is
have done
doing,
the
or
offer.
it is doing or abstaining from doing something. You are as if saying that if you deny, you
Okay.
cannot ask him to deny also or accept also, nothing, right? Because he has not, I mean, shown any interest.
Okay, so if someone doesn't show any interest, then we can take it as his denial, right?
I mean, if it is a specific contract, so for example, general offer is, it is not specified offer. So who is going to show you the interest, right?
Yes.
Hmm. Achha, there was another class of offer. What I mentioned is implied offer. Implied means when it is implied that you are bound to pay. Just the example you have given there, it is not implied. What is the example of implied? Say you are just taking a public bus or a train you are catching. Then you need to pay the ticket. You need to pay the ticket to the conductor, right? So since you
Yes.
are availing the service, that means it is an implied offer. You need to pay him. So now if you deny to pay him, that is, you are, not fulfilling the contract. Okay, so this is the implied offer. When you are taking a service, you need to pay for it. Okay, so this is an implied offer where it is not mentioned specifically also like the general offer. Okay, the next is the, let me, I mean, quickly uh, this cover this thing, the acceptance. Who can accept in case of like an offer, in case of a specific offer to be accepted by that definite person or that particular group of persons to whom it has been made and nobody else. In case of general offer, an offer made to the world at large or public in general can be accepted by any person having the knowledge of the offer by the fulfilling the terms of the offer. Also understood. Another thing is, just like your all financial analysis, there cannot be a right or wrong, because by looking at the same financial statement, one investor takes one kind of decision, another investor takes another kind of decision. Because of their, it depends on the understanding of the financials, as well as the risk perception of the investors. Some investors are risk averse, they may not be interested in highly leveraged companies, but some investors are risk prone. They are very much interested in highly growing companies, right? I mean, so it depends on the risk perception of the investors also. Similarly, in case of the contract, when you are going to answer the questions, or when you just trying to understand, so there may not be any right or wrong. You need to justify your logic. Whatever you are putting, you need to justify based on your understandings. Okay, when you are going to answer, if you can justify your points with the help of the elements of contract, or the elements of offer acceptance, or whatever, with the help of the guidelines, so then you will be the winner. Okay, so that's why in law also, I mean, many wrong things also, I mean, that gets acceptance, right? Because they have the justifications, they I mean, take the help of law, but with the boundary of that legalities only, they put their points with justification. So now who can accept, how to make acceptance? And again, express acceptance. Express acceptance where it is made by word spoken or written. Implied acceptance. Implied acceptance in which is made otherwise than in words. It is inferred from the conduct of the parties or the circumstances of a particular case. Uh, what are the legal rules? Just like the offer, it is absolute and unqualified. What is the manner of the acceptance? It is written or verbal or what? The communication must be proper. By whom, to whom, that you need to be careful, and before the lapse of the offer. If there's a specified date that
Ma'am,
beyond that the offer is going to be lapsed, so then before that your offer, before the lapse of the offer, if you do not accept, then it is not a valid acceptance. Yes. Who was
ma'am Divyam. I'm in that
Divyam? Yes,
case
Divyam.
of a company that wrote in the newspaper that if you follow this procedure and if you get influenza, I will pay you $100. So that lady did she had to accept the offer when the when the news was out, like, and she had to send that I'm accepting this offer, and then she had to start taking them that smoke ball or
No,
something.
no, no, no. Why he is
Okay,
going to accept the offer? It is meant for the mass, and since you are making the offer, that means, and if you are not now, if you are not keeping your words, so already that means it is presumed that it is accepted by everyone. Your words, right? If they can
okay,
use, they are not going to suffer from influenza.
yes,
But if they get it, that means you are deviating from your words. So now he can sue you.
yes, ma'am. Okay, okay, so it's
Communication of
because of the words.
yeah. Huh. So communication of offer acceptance and revocation must be complete so as to bind the concerned parties, because as soon as the communication is complete, the parties lose the right of withdrawal or revocation. Okay. So it is binding. Communication is important. If you do not accept, then you do not have the right of the withdrawal or revocation also. Um, the communication is complete when it comes to the knowledge of the person to whom it was made. So now just follow the dates. Though nowadays we do not make the transactions in terms of letter and so, but there are many but it is to make you understand about how to I mean the meaning of this communication, right? Just read the example. A proposes via letter to sell a house to B at a certain price. The letter is posted on 1st May and reaches B on 3rd May. The communication of the proposal is complete when B, the offeree means who accepted, the acceptor, receives the letter that is on 3rd May. So the communication is complete when somebody receives it, that is on 3rd May. Okay. So it is complete for the proposer, that means who is making the offer, when it is put in a course of transmission to him so as to be out of the power of the acceptor. That is when the letter of acceptance is mailed by the acceptor. What do we mean by that? That means when offerer, you are making an offer, and the acceptor, it is not anymore in the hand of the acceptor. The letter has been posted by the acceptor already. Then the communication of acceptance is complete for the proposer. And from the acceptor's point of view, when it comes to the knowledge of the proposer, that means when the letter reaches the offerer, then the communication is complete from the point of view of the acceptor. So you understood? From the proposer, from the offerer, when the letter has been posted by the acceptor, the communication is complete. And when the letter is reached the offerer, then the communication is complete from acceptor's point of view. Okay, so there was an example that I will discuss later on, I think, but I mean, just very fast, let me discuss it. We had been supplying coal to a railway company without any formal agreement. Later on, both parties met and a draft agreement was drawn. The agreement was approved by B and then sent to the railway company for acceptance. Now, the agent of the railway company, however, put the draft in the drawer and forgot. So it is held as acceptance was never communicated to the offerer. So you understood? So it has been, agreement has been made. The agreement was drawn and it has been approved and sent also to the railway company for acceptance, right? So it has been communicated. Now, the railway company's agent, they have forgotten. So it is not that they have communicated it to the offerer, and that's why it is not a contract. So you cannot say that I have sent it, that means it is done. You have not, I mean, they have not yet sent. So it is not complete. The communication is complete even from the perspective of the offerer. So if he has sent it and it has been missed somewhere in between in transit, then it is a valid thing. But since it is not been sent, so it is not valid. The case is held. Okay, so the communication of revocation that I will discuss tomorrow. Let me take your attendance. I am closing the class today here only. It is 11 already.